Lawyers of Reddit, what is a detail that your client failed to bring up to you that completely lost you the case? Opposing counsel, isn't it true you hit victim in the face with a brick? Client, no. Marcus hit him with a brick. I hit him in the back with a piece of wood. Head sent a photo of his wife's beaten face to his wife with a message saying something along the lines of this: do you want this to happen again? He came across very well in court up to that point, but his mask slipped when that came out. He sounds like someone I know. He can keep the mask on for a while, but it starts to slip when his perceived world isn't reality. A buddy of mine cases a public defender. A gal was busted on drug charges and told him she didn't have any drugs on her when they arrested her. He thought, okay, well, use that. Turns out, she didn't have any drugs on her when they arrested her because she just sold them to an undercover cop. Little late to the party, but here goes. And obligatory, not my client. Company I worked for at the time was doing due diligence before acquiring a small tech startup. The COO of the tech startup was a well-liked guy in the company, friendly and outgoing, though we had heard rumblings that the COO was rather hands-on with the work and with female employees. Apparently there was a walk-away package proposed to the COO that would let him keep a sizable portion of his post-acquisition bonus because a young woman who worked in their sales department had filed complaints against the COO and obtained counsel. I sat in on the meeting with the COO and the company's retained lawyers while they grilled him about his contacts with the young woman. The COO denied ever having contact with her within the company without multiple other people present. Those people said his behavior toward her in the meetings didn't raise any flags. The COO emphatically denied having any contact with her outside of work. The lawyers asked the question a half dozen different ways and each time the COO denied any out of work contact. Later we meet with the woman and her lawyer with the COO not present. Her lawyer gives us a rather graphic card that came with a bouquet of flowers addressed to her from the COO. The guy had an account with a florist linked to his credit card. When the company retained lawyers confronted him, he said, "But I never had contact with her. It's not like I delivered the flowers myself." COO got terminated for cause so no walkaway package. At her request the woman was given PTO until after the acquisition, then moved to another one of the companies under our umbrella. Custody case. Client failed to tell me he was previously convicted of felony child abuse for breaking 16 bones in an infant's body. My house was robbed. In addition to all the stuff the thief took, he also stole a bunch of my suits and all of my neckties. I had a big collection, like 100 or so. However, the thief left fingerprints on a hard plastic box that I kept spare change in. Fast forward 3 months, the thief is caught in the act of robbing another house in the same neighborhood. Same detectives on my case on this new theft. They fingerprint the guy and the fingerprints match the ones from my house. At the thief's arraignment, I see him stroll in wearing my suit and my tie. I tell the district attorney. He says there's really no way to prove it. However, the tie he chose to wear was a one-of-kind street map of San Francisco, and I still had all the documentation to prove it. The district attorney's eyes widen, and he informs the judge. The judge has the thief placed under arrest again for possession of stolen property. The thief's lawyer was dumbfounded. It was an ice into a rough situation. Lawyer in the UK. I acted for a member of a famous paedophile hunting group. My client was charged with various offenses relating to his vigilantism, most seriously, causing grievous bodily harm with intent. He wanted me to fight the case on a public interest defense point that is not available to him in statute or at common law, contrary to my advice. I followed his instructions as I'm bound to do. If the state won't punish pedophiles properly, then it's left to men like my client to take the law into their own hands. A horseshoe argument for a whole host of reasons. His laptop was seized by police and submitted for forensic examination. He had a staggeringly huge database of child pornography on it. He himself was a massive pedo. Edit. Spelling edit 2. Spelling again. Minor traffic cases can be the worst for this, believe it or not, because they are short and simple and oftentimes the client isn't there. So if you get blindsided by something critical, there's often no chance to consult with them to turn things around. I had a simple speeding case, 70 miles per hour in a 55. No big deal. If she does a driving improvement course, they court will usually dismiss or reduce those, since her driving record wasn't bad. When I showed up for her, I found out that she had been driving 70 up an unplowed snow lane to get around all the other cars traveling in the lane that had been plowed because they were driving too slow. I didn't know it was even possible to drive 70 on fresh snow. The officer stated he'd already cut her a break by not writing the ticket for reckless driving, and the judge politely agreed he didn't feel comfortable reducing it under those circumstances. When I called her up after court to confirm, she claimed she'd just forgotten to mention it. Now maybe I've lived too much of my life in the South, but that just boggles my mind as a detail I'd forget when hiring a lawyer for that incident. I would have told her in advance that hiring us was a waste of money, not to mention the hassle of taking an 8-hour class, and she should probably just go ahead and pay this one. I legitimately do that all the time during consults. Give my honest assessment if the case is even worth doing, and so by omitting that detail she harmed herself for no reason. At least she took it well and didn't get defensive. Friend of mine is a defense attorney. He was representing a guy with a lengthy record for assault. Basically, this guy took an account unit and threw it at his girlfriend. My buddy tells me he was able to get a plea deal for 1 year probation, no jail time. The judge is all ready to accept the deal when he asks the defendant if he had anything he would like to say. The defendant responds, "Yeah, I don't know why they charging me with assault. I never touched her. I just threw an account at her. This is bullshit." Judge rescinded plea deal because of defendant's attitude/lack of remorse. Went to trial and got a year in jail. That he filmed his offenses for his YouTube channel. The cops didn't even know. A witness brought it up on day 3 of a trial. It was a nice quick change of plea that afternoon. Client said his ex owed him a lot of money and that she was trying to get out of paying him back by getting a protective order against him. Seemed reasonable, so I took his case. At the hearing it came out that they were never a couple, that he was sending 6 toys to her residence on a weekly basis, and that she never asked for the thousands of dollars he gave her over the years. Stripper. We lost. He got laughed out of court and he learned a valuable lesson. Tell your lawyer the good and the bad stuff before trial. Guy in prison hired me to request a modification of his sentence because he was doing very well, completing a lot of optional programs, no rule violations, etc. He had his family come in and pay and everything to get started. I asked the family and the client if he had requested modification before, because the law said that for his conviction, he could only request modification twice for any one sentence, regardless of if they were granted or denied. Swore up and down he'd never filed before. You can see where this is going. After spending a few hours going over records and preparing documents, a copy of the CCS, the case record, basically finally arrived. Had personally filed for modification 6 times since he was sentenced with handwritten pleadings that were all denied. So the one he hired me for was a waste of time and would never be considered at all. There's so many. My dude in a custody battle where the opposing party claims he has a drinking problem and he denies it 1000%. Even after the real talk I have with him asking him to not hide shit from me, and to be honest, we go into court and at cross-examination the opposing party provides video evidence of him finishing work, driving to an abandoned parking lot to drink a few tall boys, and then going to pick up his kid from school. Every single access visit. He not only didn't tell me that, he forgot to mention that his ex's brother owns a private investigator firm. F-king idiot. I'm a court-appointed attorney for qualifying individuals in family matters. Termination of parental rights case. Have been fighting to argue that parent is stable, working lawfully, has a suitable apartment, doesn't need psychotropic meds anymore, ready to be a parent, etc. After a few months of negotiating with all the parties and Department of Children, Court Services, we have a pre-trial to try and convince guardians. I meet with my client before the hearing to see if anything changed. Nope, all good. Let's get my kids. Great. That's not happening today, but let's try. We get going in court. My client, who is super hot-headed and quick to anger, gets riled up and goes off on the guardians, screaming in open court. It doesn't end there, but reveals one that no longer is working. 2. No longer in apartment. 3. Doesn't want to have a relationship with guardians despite her kids loving them. 4. Won't send her kids pictures of the toys they miss and can't have. 5. Plans on moving out of state. 6. Thinks they can live as a family off of state aid when she gets them back and is 4 months pregnant. All in the matter of 15 seconds. I was too shocked to even react. Speechless. Not the image of stability and parental fitness I've been trying to paint since last July. Edit to clarify. Client was working really hard to get everything right and legitimately had everything going for her prior to this hearing. I was not making false representations or trying to get a monster reinstated. This was a true bombshell as I did my due diligence to make sure things were on the up and up and statutory requirements were met. Things fell apart very fast apparently. This was a very atypical situation. Parents typically do a really good job working hard to meet their requirements. Not my client, but the son of the opposing party, and presumably the party himself lied about being blind to make himself seem more sympathetic as a witness. We didn't know either until he took the witness box. Their counsel asked him to take the oath, and he picked the card up and read it. That was the cherry on top of a series of ridiculous events. The judge dismissed the whole thing in our client's favor shortly after. I was a trainee at the time, but my boss, who was in her late 60s then, said it was the most ridiculous case she'd ever handled. I wasn't a lawyer in this role, but was a law clerk. This was a typical divorce case. This particular jury trial was about splitting assets and who would get what. It was a long drawn out case that took about 5 days. Right before the closing arguments, the attorneys wanted to talk to the judge. It seems as though a couple of days prior the couple decided to get back together, and instead of telling the judge and their lawyers, they just kept it a secret. We heard 4 days of evidence, arguments, brought in experts such as land assessors, financial planning people and the like, and they were back together. One of the attorneys asked to be dismissed from the case immediately and walked out the courtroom. The judge had to dismiss the jury, and the couple was adamant that they didn't think that them getting back together was a detail any of their attorneys needed to know. Edit. Yes, in some states there are jury trials for divorces. However, this particular case wasn't for the divorce, but for a cause of action stemming from the divorce marital property. It was a jury trial. I'm a public defender in an area with lots of meth use. Meth makes most people talk a lot. So I can't tell you how many clients forget to mention that they got to the jail still high and called their mom/girlfriend/buddy on the recorded jail phone, and not only confessed to the crime, but also brainstormed whatever alibi or version of events in relying on to defend them. Edit. I'm seeing this question a lot, so I'll add some info here. This is not legal advice. Just explaining things a bit more. Calls to a lawyer are privileged and generally go through dedicated lines that aren't recorded, depending on the facility. Calls to family, friends, etc. through the normal phones are not privileged, are generally recorded, and can be used in court. There are usually printed signs near the phones and a recorded warning before each call that this is the case. Employment case. We got to the deposition of my client and all set up. The first question is, please state your name. The client looks at me and says, can we take a break? We do, and she pulls me out in the hall to tell me she's lied to me about her identity. She's apparently a serial fraudster and has changed identities 7 times since the 90s. She apparently thought the other returners had somehow figured it out, and that's why they asked the question. I heard of a guy trying to appeal his disability benefit being revoked. He was supposedly a paraplegic, but the opposition had over 10 minutes of video footage of him walking, running and even jumping over a fence after the 1-minute mark. The judge said, okay, I've seen enough. Please leave. I'm actually a lawyer, but I was only watching this trial, not participating. So the case was that woman A had hit woman B in the head with a heavy beer pint at a bar, and woman B got pretty serious injuries. The defense claimed that woman A had not hit anyone with the pint, but instead had just thrown the pint into a random direction, and it happened to hit B in the head. Thus it was an accident, and not a battery. Well, the prosecution had a CCTV tape from the bar, and it was shown at the trial. And the tape clearly showed in HD as A walked behind B and smashed the pint to her head so hard that the pint shattered on impact. I looked at the defense lawyer and his jaw literally almost hit the table. The prosecutor also noticed this and asked something along thrown A. And the defense lawyer said that due to technical difficulties he couldn't get the CCTV tape open on his computer when he was reviewing the evidence. Woman A was found guilty. So yeah, I was completely dumbfounded. There's a rule you're supposed to follow when questioning trial witnesses, and that rule is to never ask a question you don't know the answer to. Despite this rule, lawyers often ask small, apparently inconsequential questions which are necessary to set the scene, but are so inconsequential or obvious that their answers are fairly presumed. This case was an exception to that general presumption. The defendant was arrested on a warrant and transported to jail. After booking him into jail, the officer returned to his vehicle and discovered a baggie of drugs sitting right in the middle of the backseat. The defendant was charged with possession. At trial, the officer explained that he routinely searches his vehicle before his shift starts and after any time he transports someone in the backseat. The defense attorney tried to poke holes in the story, but the officer's testimony was remarkably consistent. The officer was fastidious about checking his vehicle. The appearance of the drugs coincided with the defendant's presence in the vehicle. Then, as the defense attorney was running out of questions, he threw out the question, was there anyone else in the backseat of the vehicle? It was a Hail Mary. Even when there are multiple arrests, police tend not to transport more than one arrestee at a time, if they can help it. There was no reason to believe anyone else could have feasibly been in the backseat with the defendant. Though it's no surprise to you, the defense attorney and prosecutor were stunned when the answer came back as yes. Turns out, the defendant was with his girlfriend when he was arrested, and the officer courteously agreed to drive her to her apartment before taking her boyfriend to jail. This fact was not included in the police report. The officer never told the prosecutor, and, shockingly, the defendant never told his attorney. There was a palpable pause as this fact sunk in. Since there was another person in the back seat, there was more than enough reasonable doubt. Proofs were concluded, and the prosecutor threw out a half-hearted closing. The not guilty verdict was a GIF. Because of this case, I'll learn to never assume a fact, no matter how obvious it may seem. My father is a judge. I remember him talking about a case where a woman was suing for a severe back injury that she said was preventing her from working and taking care of her kids and so on. In the middle of the trial a pen rolled off the table and she is bending over trying to reach it from her chair, but pen was too far away, so she stands up and bends over and picks it up and goes back to her seat as if nothing is out of the ordinary. My dad is just looking at her and she snaps at my dad and goes, "What are you staring at?" My dad asked her if she was okay and her response was that she was fine. Her attorney leaned over and said something to her and she then loudly started complaining about her back and how much her back hurt, but no one believed her. Lol. This one ended my marriage well. It was the start of the end of marriage. My husband lost his job in the title/mortgage business. Applied for unemployment, got denied. I decided to help him with his appeal hearing. I asked him multiple times before the hearing, is there anything you did that caused them fire you? He says no, absolutely not, they fired him out of nowhere. Hearing day comes. He testifies under oath that he did nothing wrong, was a good employee, no issues. Upon cross-examination, the other attorney pulls out documents from one of his real estate closings, documents he forged and backdated. Had to admit he perjured himself. Needless to say, he didn't get unemployment and he didn't sleep at home that night. Now you put it that way, maybe I did hit the car. Simple is good. Just now saw a post of a guy, hot defendant claimed that the parked cars were at fault, that he hit them, or maybe some other drivers, or something else. Definitely not him, even though it's clear on a CCTV, as day, that he just didn't watch the road and scraped 3 cars. Still tried lifting the blame blindly. Some people are just sure that everything in the world is to blame. That's not them. Not me, but my mentor. This is the reason you never ask questions that you don't already know the answer to in court. During the trial with the judge on a divorce matter, the wife brought up that he had abused her during the course of their marriage. Client whispers to my mentor that that is absolutely not true. On the stand, during his portion of testimony, my mentor asks, at any point in the marriage, did you lay your hands on your wife? One time we were having an argument, and I held her down on the couch until she stopped arguing with me. What? My mentor said it was like she could see it happening in slow motion and all the alarm bells were going off in her head because he had never mentioned this, and, apparently, to him, this was not abuse. The judge gave wife a lot more money as a result and husband was baffled. My mentor was fuming. Eater. Husband admitted this was the only time he had laid hands on wife. My mentor was more peeved because she had thought the case was in the bag since wife had abandoned the kids with husband to run off with her lover down in Florida and literally only came back to the state to get the divorce done. Husband had been noted as being a great dad to the kids and a good figure in the community. Hence why she was so damn shocked at his answer. I was approached by this attorney to work for him for free to go after smugglers. This guy had been arrested for dumping goods onto American markets that violated trade agreements. In his arrest, a bunch of goods were left in warehouses to rot, and their owners, his clients, were never paid. This attorney showed me that this smuggler had assets and that he had gone to the criminal trial and gotten the judge to set aside $2 million of the criminal penalties to settle his client's debts. He had receipts, invoices, all of the paperwork. He just needed associates to help him take the case to trial. He wanted me to work for free, but he would pay me on contingency once he obtained the verdict. He had 2 other attorneys working for him with the same deal. I worked on the case for a short while, but luckily moved on to other things. The other 2 attorneys worked on that case for over 2 years. At one point, they negotiated a $1.5 million settlement of all claims. The attorney in charge rejected the offer because he was convinced he could get twice as much at trial. In the end, the case settled for $200K because none of the clients would enter the United States to testify for fear of being arrested. The 2 associates got $8K apiece for 2 years of work. I'm still a law student and this happened during my first internship at a court. A girl among other people was charged with drug possession, but because she had thrown away the drugs and the police couldn't prove that she bought or owned the drugs, it could have been one of the other people as well who still had drugs on them. The judge ruled in dubio pro reo. He then asked if she wants to add something, and this girl asked if she can get her drugs back. The defense attorney looked like he was about to get a heart attack. Edit. For those wondering, I know what in dubio pro reo means, but I wasn't sure if they use the term in other countries, and tried to explain it if not. This happened in Germany. Employment law matter. He claimed to have been unfairly dismissed over bogus performance management. The real reason, he organized via Craigslist to have someone collect a box of his camp from a children's playground. There were explicit messages from him asking what they did with it and whether they rubbed it all over themselves. The employer provided us the messages. Edit. He was doing this on company time. Client in family law matter lied to me about using meth. Then used meth with the child in the room and the ex got footage of it on the nanny cam and then made excuses about why they couldn't do a drug test, then blamed me when they lost custody. Despite the fact that they didn't show up to appointments or return my calls, so I couldn't prepare any court material. I dumped the client after that and left family law. I was actually on a jury. Guy was suing a business, said he got injured, couldn't work for 3 years. Defense counsel: sir, isn't it true that you spent 18 of those months in prison for armed robbery? Edit. For more info, guy was saying he was shopping at a major grocery store chain and slipped in some water on the ground in front of a freezer. Guy has cell phone video his wife made of him in the water and we could hear her saying that the water wasn't showing up on video and to splash it with his hand so it would look better in the video. It also came out that Head had 3 prior convictions for crimes of dishonesty. That may not be the exact term, but something similar for things like shoplifting and other petty crimes. Second edit. For more info, while I'm on my lunch break, Guy was representing himself pro se. Defense counsel asked him if his inability to work could be from the 2 previous knee injuries Head had. When asked how they knew about those injuries, he was told his previous lawyer had given the defense's medical records upon request. Guy wanted to enter his MRIs as evidence, but had no one there as an expert witness to explain to the jury what they showed. He wanted to show us what the results were,